Global happenings today. We communicate, we analyze global news. Stay tuned.
Hello beautiful people, welcome back to Global Happenings to the YouTube channel. Still on the issue of PEPC, Presidential Election Petition Court. Remember, we have about 180 days to summarily conclude this whole thing, and we're in the final stages of the final written addresses. Of course, APC have written theirs, INEC have written theirs, Bola Ahmed Tinubu, Shetima have written theirs. Labour Party have also responded to almost all of them. He has responded to Bola Ahmed Tinubu Shetima. Check our playlist, you get to see that. They've also responded to APC as well. Check our playlist, you get to see that. And of course, this time around, they are responding to INEC in their final written address, and it is Bombard packed as usual, laden with a lot of fact, figures, and documents to prove. And if they need technicalities, Labour Party's lawyers are also equal to the task. You're going to find out why I said what I said as I read through, in summary, what they wrote as their final response with an address to INEC. Well, before we do that, kindly subscribe to our channel by clicking on the red subscribe button. Beside it, you will see a bell notification icon. Please go ahead, click on it to get notified as soon as you update our channel on YouTube. Well, Labour Party started by saying that it is difficult to comprehend why INEC would abandon its primary responsibility of being an electoral umpire and proudly put on the toga of a candidate in the election it conducted. They further stated that INEC didn't release relevant documents to Labour Party despite court orders. They continued by raising three issues for determination. One of them is the fact that the first was as regards to whether Bola Ahmed Tinubu and Shetima were even qualified at all to contest. The second was the fact that on non-compliance of INEC to electoral guidelines, and of course the third one was the qualification vis-a-vis the non-compliance. On the first issue, they defined money laundering and mentioned the fact that its nature and character clearly involves dishonesty on the part of the person who engaged in money laundering, as in this case, Bola Ahmed Tinubu. Labour Party argued that APC, in their final address, were wrong to say that a conviction must exist before a person will be disqualified from contesting for the office of the president. They also argued that the U.S. District judgment tendered was in full compliance with the law. They further argued that by the express meaning and intent of Section 137, subsection 1, subsection D of the Nigerian Constitution, a person who, even though not convicted, have forfeited property on account of criminal conduct should not aspire to or be allowed to occupy the exalted office of the President of Nigeria. On disqualification of Shetima, they relied on section 142 of the Constitution, which provides that a person shall not be validly nominated unless he nominates another candidate as his associate. They also relied on Section 34 of the Electoral Act, which is on a double nomination, and argued that Shetima's nomination as a senator was never withdrawn by law. They argued, relying on PDP versus Dege Eremiano, that for the reason given, both candidates should be disqualified, reason being that their joint ticket is vitiated by the disqualification of Shetima. On the second issue, they argued that through the documentary evidence before the court and the unchallenged expert and technical evidence of Labour Party's witnesses, Labour Party has proved that the non-compliance by INEC with the relevant provisions of the Electoral Act and the subsidiary legislations substantiatedly affected the outcome of the questioned presidential election held on 25th of February 2023. Furthermore, Labour Party argued that the election manual and regulation is a subsidiary legislation which has the force of law. They have their own origin from the Constitution and the Electoral Act. They argued this relying on Falake versus INEC, stating that INEC should have complied with the manual as regards transmission. As regards the Federal High Court judgment relied on by INEC, Labour Party argued that the decision in Oyetola versus INEC, which is a Supreme Court decision, overrides that. In the said In the said case, the court held that while there is no part in the Electoral Act and INEC guidelines that require that election result of a polling unit should, during the polls, be transmitted on the spot to the INEC National Election Register database, the regulations provides that the beavers be used to scan and complete results in Form EC8A and transmit or upload the scanned copy of the polling unit result to the collation system and INEC result viewing portal, otherwise known as IREF. In addressing the testimony of witnesses, Labour Party argued that INEC, in an attempt to discredit the evidence of witness 7, described her as a person of interest in the outcome of the proceedings. However, she tendered documents which are publicly accessible, and they also mentioned that INEC did not deny hosting its servers. They further argued that INEC's witness in paragraph 27 and 28 of his witness statement on oath misleadingly and incorrectly claimed that all polling unit results at the close of polls were immediately or timeously uploaded. Now, and still went ahead to state that the downtime encountered on the application lasted 4 hours 50 minutes until it was resolved, and the first presidential result was successfully uploaded at 8:55 p.m. on the 25th of February 2023. They further argued that believing that the blood certified copies which INEC sole witness claimed to be the copies of the original is like believing that you can harvest apples from palm trees or apples from pawpaw trees. They further argued that the unchallenged expert evidence of the Labour Party's obese witnesses, including the documentary evidence before the court, have established that non-compliance of INEC in the circumstance of the instant petition were not only substantial but grievously affected the outcome of the presidential election. Still, on the evidence of INEC sole witness, they mentioned that in a futile attempt to justify the technical glitch, INEC witness 1 tendered an alleged AWS CloudTrail logs showing the touted technological glitches, but on cross-examination, his evidence showed that the evidence he tendered didn't meet the criteria a CloudTrail should have. A CloudTrail should ordinarily have an event time, event source IP address, and so on and so forth. But the one tendered by INEC witness did not have most of these criteria. On substantial non-compliance, the petitioners mentioned that they tendered 18,088 polling unit results downloaded from IREF portal, and they were admitted some were blurred and some showed pictures of unknown persons, yet INEC certified them. Labour Party mentioned that INEC officials, with respect, must have a bizarre sense of humor to have done that. They mentioned that ordinarily, the result on the IREF should be exactly the same with the hard copy and not blurred. They mentioned that the non-compliance affected 14 states and 168 local government areas as evidenced by the exhibits tendered. On issue 3, as regards the return of Bola Ahmed Tinubu and Shatima, they based their argument on the fact that Bola Ahmed Tinubu did not obtain up to 25% on the Federal Capital Territory, Abuja. Labour Party argued that holistic reading of Section 299 of the Constitution seems to suggest that the FCT will be considered as a state for the purpose of enjoying the executive, legislative, and judicial powers vested in a state. Hence, the FCT is exclusively administered by the President. The National Assembly legislates the local laws of the FCT, and the FCT High Court is the court with territorial jurisdiction in the FCT. They further submitted that FCT will be regarded as a state to that extent alone and no more. They argue that the Constitution gives the interpretation that a winning candidate must have 25% of total vote cast in 2/3 of the states in the Federation and the FCT, Federal Capital Territory, meaning that a winning candidate must obtain 25% in 24 states and also 25% in FCT. They further stated that Part 2 of the second schedule lists the states of the Federation and the FCT is not included as a state. Conclusively, they respectfully argued the court to grant all their reliefs. Wow, this is not only bomber packed. They took time to address many issues. also including, not limiting to the fact that INEC should be an umpire, and that's why umpire should stand alone and not defend itself in this matter. They didn't stop there. They also went further to talk about that last witness. I can't forget that last witness, where he took time to explain the mail trail, the issue of the final forfeiture of $460,000. They took time to explain that. In fact, they spoke at length. If you remember, just a quick summary, this whole thing is 82 pages. It's a joint written address where 42 was for APC and 42 was for INEC. Powerfully written, I must say. Let's see how the judges will give their verdict as we await PDP's own final written address. Then the verdict will start flowing in.